Greetings and welcome to Module 4 of the Civil Rights 101 training course. WSU Extension's Civil Rights prepared these lessons to provide basic understanding of why civil rights matter in your work. This final lesson offers a high-level overview of how civil laws are applied in Extension. Dr. Kenitra Keeney, along with the support of the University of Wisconsin-Madison Extension's Office for Access, Inclusion, and Compliance, collaboratively worked on the content for this 4-module training. WSU is an equal opportunity service provider.
In this lesson, we will discuss some basic civil rights requirements, including public notification of rights, language access, and reasonable accommodation. We will also discuss the importance of collecting and maintaining documentation and ways in which that documentation is reviewed. Note that these compliance requirements are just the floor. We must go beyond compliance to fulfill Extension's commitment to expanding access and ensuring equity and programming. Let's begin with Extension's obligation to notify the public of their rights. By law, we must let the public know that Extension is an equal opportunity provider that does not discriminate. We are required to prominently display the "And Justice for All" posters shown here. Wherever Extension work is carried out, including local Extension offices and other locations where programs are delivered. The green version on the screen is for all other Extension programming. The posters, which are in English and Spanish, explain that Extension is prohibited from discriminating against protected groups. As we learned about in Lesson 3, the posters also state that program information may be made available in languages other than English, and that persons with disabilities can request program information in alternate formats. Lastly, the posters explain procedures for someone who wants to file a program discrimination complaint directly with the U.S. Department of Agriculture. If you conduct programs or activities in places other than an Extension office, be sure to bring a copy of the "And Justice for All" poster with you. Now we will learn about language access requirements and procedures. In previous lessons, we learned that civil rights laws require Extension to provide meaningful access to programs for individuals with limited English proficiency, or LEP. Let's look more closely at what this means. LEP refers to individuals who do not speak English as their primary language and/or who have a limited ability to read, write, speak, or understand the English language. Note, the LEP person may be competent in English for specific types of communication. For certain types of communication, example speaking or understanding, but still be limited, English proficient for other purposes, such as reading or writing. Extension is legally obligated to provide free language support services, such as translation and interpretation anytime they are requested by or for an LEP person. As with language access, Extension is required to provide reasonable accommodations for individuals with disabilities. What do we mean by reasonable accommodation? Accommodations are context-specific. They vary based on what would allow a particular person with a disability to enjoy an inclusive and equitable experience. Remember, not all disabilities are physical disabilities. Accommodations could range from providing an audio version of a paper manual to arranging for a personal support person to attend an event with a youth who has an intellectual disability or mental health diagnosis. Reasonableness is evaluated based on the timeliness of a request and whether it will fundamentally alter the programming. There are more resources available on providing reasonable accommodations. Now we'll discuss collecting, maintaining, and reviewing documentation of civil rights efforts. Our federal funding partner, the USDA National Institute of Food and Agriculture, requires that we keep documentation of our civil rights efforts. What does this include? A record of your intentional efforts to reach out to protected groups. Basically, your files should tell the story of your efforts, relationships, and strategies. Keep samples of your program materials, including flyers, brochures, and handouts, and any other materials you've had translated into other languages. These should show that you have included non-discrimination and accommodation statements. You will also want to document any language access services that were provided or disability accommodations that were made. The USDA also requires that we collect demographic data on our program participants, including race, ethnicity, and sex. We usually attempt to collect this information when participants register or in a survey at the end of a program. The demographic information collected is a key component of the records that extension educators put into the planning and reporting. It helps us determine our progress towards parity, both at an individual and organizational level. Parity is one measurement of our success in civil rights compliance. Now let's review. In this lesson, we reviewed specific ways that civil rights laws are applied in extension by providing public notification of rights using posters and non-discrimination and accommodation statements. Also, by providing language access through translation and interpretation services, by providing disability accommodations and using an accessibility mindset in planning our programs and documenting our civil rights efforts and reviewing our progress towards parity. Thank you for your time and attention.